turned. And that's what you'll need to do in order to be heard in the room and on Zoom. And all you have to do is where it says push, it'll turn the mic green and you'll be live and ready to go. Restrooms you passed between here and the elevators, they're just to the right of the door out the hallway. And with that, where did he go? Oh, there he is. I'll pass to Robert to welcome us back for our third long-term competency subcommittee meeting. I missed the last one, so I'm happy to be back. Allison's on her way. She was just stuck in a little bit of traffic, so she'll be joining us in a minute. So thanks, Robert.
Welcome. Today, Allison's like...
You may have to...
Oh, sorry.
Sorry.
That's all right. Welcome back. I'm glad everybody came back. I'm eager to get into it. I don't have much to jump into other than when we talk a little bit about today about evaluations. I will say, in prepping for this, Allison, myself, and the folks at Barley and Summer were sort of debating how we move forward, realizing that there is 6 different intercepts in our plan. When we say intercepts, we just mean the point of contact for the consumer at different points of contact for the consumer in the system. And we realized that with 2 weeks, if we did all 6 and we did 1 a week, that's still 3 months, and this is due in December. The plan itself, there's still opportunity to talk about the broader opportunities of the criminal justice system and folks that have mental health and what we can recommend. Now, there are other committees that exist, so what we'll do is bring those folks in as well when the time is right for those other systems. But today, we thought we'd start with what the Colorado Department of Human Services is responsible for in the system, which is the evaluation and restoration component. We'll start there and then move to the broader system. So law enforcement is the larger system, and then we'll move, the court is a larger system, and then community services as a whole is a larger system. We thought we'd start really specifically on those 3, but we should probably do introductions first, real quick, just if your name, what organization that you are from. So thanks, welcome.
And I can request that you use the mic to do that so that people who are joining us by Zoom can hear us. And just a little quick Zoom housekeeping as we do introductions. So when it's your turn, you just have to press *6 if you're on a phone to unmute yourself. And Emma is manning Zoom for us so she can see you on chat as well. So if you have questions for her there, you can send them in. So Lacey, do you mind starting for us?
Dr. Lacey Bruman, and I am with Track Tech and a former National Board of Director for NAMI.
Lucy Ohanian, Colorado State Public Defender.
I'm Juan Silva. I'm a Senior Deputy District Attorney in the DA's office in Denver, and I'm also a Board of Director for Mental Health Colorado.
Mary Thomas, and I have lived experience.
Emma Gilchrist with the Farley Center.
Emma, do you just want to do Zoom while you're right there, or you need a second?
I like to give them a little warning.
Okay.
Yeah.
Summer Gathercole, your facilitator for this whole process. And I just also want to jump in and say, just to lighten the mood, that I left my dress shoes sitting in my garage floor, so I'm wearing flip-flops today, and I'm very old school, and this is totally embarrassing. So thanks for putting up with that.
Peggy Heil, Department of Public Safety.
Joy Hart, Colorado Department of Corrections.
Jessica Russell, Director of Crestone Recovery Services at Health Solutions in Pueblo.
Moses Guru with the Colorado Behavioral Health Care Council.
Hartley Salon, Mental Health Center, Denver. I'm the Assistant Program Manager for the Crisis Intervention Response Unit.
Brenda Pace with Pueblo County Attorney's Office.
Sue Coffey, I'm a facilitator for AFSP and a parent.
Ben Harris with the Colorado Department of Healthcare Policy and Financing.
Well, and I have to say, Summer, I've done the same thing. I gave a presentation in Baltimore and Birkenstock, so if that makes you feel better, I can relate. And go ahead on the Zoom.
Okay, so on Zoom, I can see we have at least 2 subcommittee members. So Laura, I'm going to go to you first for a quick introduction to just unmute yourself. She's introduced herself on the chat. And so as a reminder, it's Laura Warner from San Juan Basin Public Health. And then we also have Brian Gonzalez.
Yeah, good morning, everyone. I'm Brian Gonzalez with the University of Denver Graduate School of Social Work.
All right. Do we have any other subcommittee members joined by Zoom?
Yes, this is Raina Shaner, lived experience.
Hi, Raina.
Hi.
And then Sasha, I'll give you an opportunity. We're just doing name and organization.
Oh, yeah. Sasha Wright, Denver Sheriff's Department, Health Services.
Great.
And we're expecting Judge Seamus by Zoom, but I don't think he's joined yet. So
okay, good. All right. So as we get started with I'm Stephanie Kirshner. I guess I should have started with an introduction for me. It's nice to see you all again. I'm with the Farley Center and working to facilitate, thank you, the task force meeting. So we're happy to be here with you on this Monday morning. We have found in other subcommittees and in the larger task force meeting in the last month or so that this parking lot concept has become more relevant to our work as a group. With all of the discussion and all of the concepts that are being introduced, it's really easy for us to get off on conversations which are important, but maybe not quite as relevant to exactly what we're trying to accomplish that day or in that moment. And so we're trying to really direct those to the parking lot for a couple of reasons. One, so that we can circle back and answer any questions. You can share concerns that way if it's a more comfortable way for you to communicate, and really just helping us to remain on task. So we'll probably remind you of that as we go to we put sticky notes out. You can write your thoughts down, post them on the parking lot, or hand them to any of us, and we will make sure that those get incorporated into notes and planning. It's also been a nice way if you think of, oh, I'd really like to learn more about this, and we can consider that for a future agenda topic as well. So we'll be encouraging you to use that actively. And today, really, we're going to jump in for a Monday morning to really get towards the discussing the function and priorities of this subcommittee. Unfortunately, the last time we met, we didn't have time for this small group discussion, and it's just a really important thing for us to come to center on before we move forward and start jumping into the intercept model. So we're going to spend some time right away breaking up into small groups to have that conversation, and then we're going to come back together to then begin thinking about the work on Intercept 3 that we asked you to read before coming today. Robert's going to ground us a little bit with context around what that is, make sure there's no questions, and then we'll move into discussion as a full group around the recommendations that come at the end of that chapter. And that's going to take us 2 hours, I'm pretty confident. So what I'm going to ask you to do is count off. I think there's probably, I had 5 groups, but I think probably 4 is enough. So count off by 4. And I have group 1 over here by Robert, group 2 right by me, and then 3 and 4 are over in these smaller square tables, so you can have opportunities. But I would ask that we move in and out of these discussions as quickly and efficiently as we can, because we're finding that's a place where we're losing some time in other meetings. And we'll give you an opportunity to really think about those questions. And we have worksheets for them, and then we'll have a little report out at the end. So any questions about that? And those of you on Zoom, Emma will be putting you into virtual breakouts so that you can have an opportunity to work together as well. All right. Cool. Sasha, I'm going to ask you to start numbering off by 4s, and then group 1, 2, 3, 4.
1, 2, 4. 1, 2, 3, 4, 1, 2, 3.
Cool. Go. And we'll bring the worksheets around to make sure you have those to guide your conversation.
Hi, how are you?
let the groups begin to report out based on their discussion. So number one, who'd like to report out? All right.
Okay. Good morning, wake up. This is very quick, and we're feeling like we didn't cover as much ground as we would have liked to, but question number one, we really felt like the initial effort of this group should be focused on the court process, and that's the point at which the person is arrested, simply because there's other groups working on this, because that's when OBH gets involved with the person in competency. So initially we should focus on that, but that we feel like we don't want to let go of the broader issues that implicate the person initially getting arrested and then the consequences of the release after the case is done. So, and second to that, I think we felt like the question of, is it about getting someone well enough to stand trial itself assumes a premise that we don't necessarily agree to, which is that part of once competency raised, part of the process should also be finding ways out of the case short of trial, prosecution, plea. So those are two things we'd like to include in whatever the function of the subcommittee ends up being determined. Some priorities that we discussed were pre-competency interventions, so whether competency has been raised or once raised, interventions that can be done short of the restoration process or in advance of that. How to address the frequent cycling of some folks who come in and out. Some of my notes are. So how do we speed up the process of evaluation? So do we look at considering those who have had multiple competency evaluations that maybe those can be done quicker, or there's sort of a presumption of incompetency? How do we look at folks with IDD, TBI, or other sort of types of illnesses that are not going to respond to medication and that are not going to respond well to restoration efforts, and looking at misdemeanant cases and how do we speed those along or find a different way out short of going through the whole competency process. We talked about condensed report writing and other ways to get access to evaluators than the many distances travel and the difficulties in scheduling those. Okay. Did you mention that? Yeah. Oh, yeah.
Great, thanks. I think we're going to go to this group.
And Laura's going to report out on behalf of the Zoom group.
Hi, this is Laura Warner. Just wanted to check that you can hear me.
Okay.
Yes, we can hear you. Oh, okay. Wow, this is so challenging. So we discussed for the first question that, yes, I think our initial goal is to meet the terms of the the consent decree, but we also don't want to forget that we're part of fixing a larger behavioral health system. And so with the specific population of folks facing competency questions and utilizing restoration services, really we want to remember, how can we serve them better as a whole, keep them from even entering this process if we can. And then for priority issues, a couple of things came up. As was just spoken about, a lot of the people, I think, who are involved in this process go through it multiple times. And so one priority would be to delve into what are the reasons that they're returning to us. So are there ways that we can better treat the underlying mental health conditions? Are there other social determinants that need to be addressed, like family support or housing or transportation? And then I think the other priority would be ensuring that those of us who are providing services to this population are trauma informed and not feeding into the drivers of why people kind of keep revolving through this process.
All right, so we had a lot of similar themes to what the other groups all reported. One of the first things we talked about, like the other groups did, is that while we do have an immediate charge to look at the competency process, we don't want to there like a specific range? Okay, we don't want to lose sight of the opportunities for diversion and for going upstream with intervention, and making sure that whatever decisions or recommendations we make in this group, in this report, are really cohesive towards that vision of going upstream. So we may have to work with some of the other groups, the safety net subcommittee or others, to make sure that we're not making decisions in a vacuum, and that we're not putting resources or efforts just to address an issue that hopefully we can prevent in the future, so that we're really being strategic about that. We also talked a lot about what we're doing to focus on where we really have opportunities for impact, especially just knowing that we don't have a lot of time for these recommendations, so that we do have to pick how we can be the most strategic. So we talked a little bit about having a two-pronged approach, perhaps, where we think for the future, but act for today. The other thing we talked about in the statement is that improving the process for someone to get well doesn't quite resonate with our understanding of what competency is intended to do. It doesn't necessarily have to do with the person's wellness or health. It really is just about their legal standing to stand trial. So we thought that it might be important to clarify that in these statements and the way that we talk about what we're trying to impact here, so that we understand that we still have work to do beyond just the competency process to address wellness. With all of that, we found out there were opportunities in looking at how do we get some pre-screening or other interventions before we commit to the process, similar to what Group 1 talked about. How do we commit to shifting to the community, and what resources do we need to build around that to make sure that those that shifting is really effective? And then how do we build in some more quality oversight into the efforts that happen in the restoration process itself? And in looking at that, do we look at the curriculum? Do we look at what resources are tied around the education? And how do we just measure really strategically what we're trying to impact through this process? With all of that, there was, of course, the common theme that we need to be very cohesive with a long-term plan and not just making decisions to address the current acute needs, but really thinking strategically.
So, all right, so not to regurgitate everything that's already been said, since we're probably all more or less on the same page, which is to operate in a vacuum would be a mistake. Even if you take the different subcommittees aside, everything having to do with mental health, specifically this subcommittee, will cross various lines, whether it be between adult and juvenile, and or crossing between criminal and civil. Specifically, that first question talks about standing of trial. So we'd be talking about in a criminal realm. I think what we can all agree with specifically in this group was that there's a need and a necessity to address those issues well before we get to the issue of can they stand trial, which then obviously combines with what can be done in a civil realm before even the criminal field is involved. Taking it a step further, if we're not acting in a vacuum, we have to be conscientious of the fact that since there will be interplay between the civil and criminal realm, that we will need to be realizing what can be most effective, whether it be costly effective or just more effective and going to operate in the best interest of the individual who we're trying to help, as to whether the civil realm is going to be the best way to address the issues of that individual, or complicating and addressing those issues in the criminal realm. Those are important because, as we're all aware, with the change in legislation, which some of that is addressed in the master plan, there are now tools that can be used or procedures that can be used to take individuals from the criminal realm and put them into the civil. So a long way of saying that we agree with everyone else who's spoken thus far that yes, the priority of this group is to be very focused and narrow, but we have to keep in mind that there are other areas of the issues of mental health, specifically the subcommittee, that can be addressed by focusing on some of these secondary issues. As to the priorities and other issues that the subcommittee should be addressing or focusing on, it'd be the same thing you all have been talking about, but more importantly, just the simple fact of making sure we have a larger umbrella and then more focused narrowing as to specifically what the subcommittee is supposed to address, but understanding pretty much everything you all have spoken about is those additional issues that we need to address within the subcommittee.
Okay. So ours is very similar to everybody else's. We started out with not allow mental health, cognitive health, behavioral health to interfere with timely due process rights. Within that, to solve the backlog to access to services for individuals, as well as prevent unnecessary entry into the sort of the court criminal process when it's not needed. And then as far as the priorities for the subcommittee, aligning competing systems in regards to an individual who has these clinical presentations in the court process, avoid the cycle for reoccurring individuals. Is court-ordered outpatient treatment the answer? What is the role of pretrial services in court-ordered outpatient treatment for individuals that are cycling? And then no centralized there's no centralized coordination and ownership of care to sort of solve that issue of nobody playing the not it game.
Right, I can speak loudly while I'm looking for a mic. So what we're going to do next is really try to take the notes that you have been taking. We want to keep those. And so if you can leave them behind, that would be helpful for us. And the Farley Center team will try to pull all this together into something that feels cohesive to answer these couple questions around really what is the vision and the work ahead for the subcommittee. And then we're going to circulate that to you in the form of a survey so that you can respond to, yeah, we're good, I can get behind this. No, there's major things that need to be changed, and here's what they are, or here's a few tweaks that we'd like to contribute just to make sure that we get the language right. So a lot of this wordsmithing related to this we can do between meetings and come back with something that feels a little bit more concrete. So that'll be next steps of this work. So in addition to what we've taken in minutes and on your notes, we have our own notes too. We'll be combining all of that before we meet again and make sure that you have that survey in between the meetings. Okay? All right, so with that, we can move back to our original seats. And I'm going to keep talking a little bit while we move. And I wanted to remind you all, as the next discussion we have, we're going to try to have as a full subcommittee. And so the operating agreements that we discussed at 2 meetings ago, and probably when I was sitting on the dock in Michigan last time you all met together, will be really important in this kind of opportunity as a team. Primarily, the need to step forward and to step back is something that I think is really important for all of us to keep in mind. We really want to hear from everyone. And so if that everyone becomes just a couple, that can be a signal to you and maybe from us directly that stepping back is a huge part of participating in the subcommittee as well. So we'll give this a shot this morning. Robert's going to start us off with his 19 slides in 5 minutes. And I know that he can do it, just to give us a little bit of context around what is Intercept 3, and then we'll start diving into questions from you to clarify anything that you're not understanding. I know we did this a few weeks ago at our kickoff, kind of on a broader scale, but this will really be focused in on just this one intercept, and then we'll start into our discussion as a subcommittee.
Yeah, and we will move. I will move quickly, and if I move too quickly and somebody has a question, just raise your hand and I'll try to answer it as best as I can. It's sort of just a little bit of level setting. I think everybody's familiar reading the report that there are 6 intercepts. Today we're focused on Intercept 3. And then for Intercept 3, there's sort of there's 3 key areas. People get their competency evaluations in the community, in jail, and inpatient. Most competency evaluations happen in jail, and they must be completed within 28 days of the court order for evaluation. If it's inpatient, we must admit the patient within 28 days of the court order. Those are timelines for now. Those timelines will move up in future years as part of both statute and the consent decree. Stephanie, is this coming through?
I think, Emma, can I hear on the line? As long as we can hear on the line, I think we're okay in the room.
All right, I'll move forward. Just let me know if it's not coming through. And then obviously the ideal is the on bond out of custody, but that's not utilized as heavily as the jail court-ordered jail evaluation. We'll talk really quickly about the triage system because that is new to the evaluation process. The forensic support team is also new, and the Bridges program is relatively new. This is the referral list since 2001 for evaluations. You can see that it's been going up. The blue line is for inpatient, the red line is jail-based or community-based, and the green line is the total for the two. Now you'll see that both the blue line and the red line go up from 2001 to about 2011, and I don't know, I forget exactly when the new statute enacted, which basically raised the bar for court-ordered inpatient evaluations, that the court sort of basically had to make an argument why it needed to be inpatient and why they needed to take a bed in the hospital. That really helped level out the inpatient evaluations, but you see that the jail evaluations keep going up. This is a phenomenon that's happening across the country, but I don't really know the root cause. Do we really believe that all of a sudden people in 2012 more people got sick? I don't think we believe that per se. We do know the population continues to grow in Colorado, but not at the same rate we're seeing here. We also know there's a lot of reoccurring of the same individuals into the process as well. What I didn't mention here is that about in that red line, about half, and I'm being really rough here, about half are found competent to proceed. The other half are found incompetent to proceed. So that's another question too, is sort of, we can get into it at a further date, and then we've been discussing with the special masters is sort of, is there a screening process we can put in place that would better identify those people that are competent so they don't have to go through the full evaluation process. Inpatient competency evaluations, you can see they're relatively low per month. Last July we had 12, and that's good. I mean, that means that we're only admitting those that really need to be admitted. Hopefully that's what it means. And we're doing a lot of same-day evaluations. So we've adjusted our admissions process where the evaluator, someone shows up at the hospital, and we're able to get the evaluation within the same day or within a couple days and return a person back so they can continue on with the court process, unless they're found incompetent. If they go to inpatient and they're found incompetent, Senate Bill 223 now has us, we may, and we're figuring out the may part per statute, may hold on to the individual to begin restoration in inpatient. So we're kind of working with special masters, DLC, and then eventually with the courts about what that looks like. If that's something that needs to be on the form for court, because the may can be tricky. Real quick, these are by day. You'll see the blue is the number of pretrial detainees awaiting less than 21 days that we're admitting. I'm sorry, the inpatient eval is 21 days already, starting last June 1st. But within 21 days, blue means we're compliant, red means we haven't been compliant. The red individual here, though, is a person wasn't medically cleared to be admitted to the hospital yet, but they have since been admitted. Jail competency evaluations and community-based restoration competency evaluation referrals. We sort of touched on this a little bit, but it just gives you a sense of individuals versus referrals. You'll see the blue line is referrals. The red line is individuals. The solid line is number of referrals. The dotted line is individuals. Individuals might get more than one referral. And jail competency evaluation wait list. So there's a number of pretrials in jail. When we get their evaluations done within 28 days, we've been pretty successful. Particularly given that July was a rough month, we had a couple evaluators go on maternity leave. We have a couple people who took other jobs, and so everybody is sort of stepping up and trying to help out in July to meet the rise in demand. So moving to the new part of the system is the triage. So when an evaluator, historically, all the evaluator had done was go in and say whether they opined someone was competent or not competent to proceed trial, meaning whether they felt that they could understand the court process and participate meaningfully in the court process. Now we've asked the evaluators to opine whether that person, if they need to be restored, whether they can be restored outpatient or inpatient. We're going to work on this language. We met with some evaluation supervisors. Right now, the question they're asking themselves is, should this person be outpatient? And we're going to work on changing that language to, is there any clinical reason why this person needs to be inpatient? It's the same answer, getting to the same answer, just asked in a very different philosophical way, where a lot of the evaluators we were learning are uncomfortable with saying they need to be outpatient because they're worried about other factors other than clinical that they're weighing in, they believe they're weighing in on, where we just want them to weigh in from a clinical perspective of whether they need inpatient. So we'll work with that. And this is the sort of what we mean by triage. You'll see on the pink side on the right, there's tier 1 and tier 2. Tier 1 means that somebody meets a clinical setting of 2765. All 2765 means it's the statute number, which means that your clinical presentation is so severe that you're a harm to self, others, or gravely disabled. I'm summarizing it, that you need to be admitted. You can be admitted involuntarily as well. This is true for the civil population. This is the population where you go to the ER and you get put on a hold because you can hurt yourself or someone else, or you're so gravely disabled. Now, tier 1 also includes this not 2765. So it's a lower bar where folks that are basically right now, this is what we're learning and trying to adhere to. But basically, if you don't admit this person within 7 days, they're going to decompensate to the point that they're going to go the 2765 route. So might as well admit them quickly. Tier 1 must be admitted within 7 days. That's the threshold. Is that if the evaluator determines you're tier 1, this is where it gets tricky though. You still have to go to court, and the judge still has to agree, and then you have to be admitted within 7 days. With the exception, the 2765 group, if you meet a clinical presentation under 2765, we can admit you against your will for clinical reasons. So and not wait for the court. And we've done that in a couple of scenarios where someone was a harm to themselves, and we needed to admit them before they went to court. And then tier 2 is everybody else, everybody that doesn't meet that high tier 1 threshold, and they either go to the community or they can go inpatient. So evaluators are opining basically about whether they need to be tier 1 or tier 2 when they make a recommendation to the court. You could see on the left there are the numbers for jail-based evaluations versus inpatient versus community. It's a lot higher on the jail-based evaluation location. And then incompetent, there's a Zack numbers on competent versus incompetent to proceed. And it's roughly 50-50 as I mentioned. And this is a slide, we're sending this out to everybody at some point, right? This slide I think is helpful for our conversations as we go forward on evaluations. This is just the similar data that's a longer about settings and year-long data on numbers and percentages I'm not going to get into because it's pretty consistent about 50-50 and mostly jail-based evaluations. Forensic support team, we've hired most of the team, all but one navigator and one supervisor. They are starting their training on Monday the 19th, and it'll take about 2 weeks, and then they'll be in place and they'll be working with the Bridges program, which is the court side of case management. So they're both case managers. They're going to work together as people flow between the court side and the clinical side of OBH as they go back and forth between those two settings and those two services. Those two navigators will work together to coordinate care. All right. The forensic support team I just mentioned. So they're intensive case managers. They'll check in with folks while they're waiting in jail. They'll check with folks in the community and make sure that the services are moving forward and nobody's stalling, and we continue to move forward, as well as working with the Bridges program to talk about what services are available in the community. There will be individuals will be assigned to specific judicial districts. The Bridges program, it's similar. It's on the court side. However, the Bridges is bigger than just competency. They're really dealing with all mental health in court and working with the judges. And this is just rolled out as well between January and last month. Sort of different districts have rolled out at different times. So we're still looking to see how the two connect with each other. They're developed, and we need to develop a responsibility matrix between the two teams, who's responsible for what, and we're in the process of doing that now. You guys heard last time that discussing confidentiality and information sharing has been a challenge, and Judge Seamus was, we connect, I mentioned it, we also connect with the Bridges program. Denver has done an MOU between the DA and the public defender to ease this barrier about confidentiality sharing and the fear of being pulled into all these different court cases. And they have an agreement between the two groups, so we sort of avoid polling navigators spending all their time in court. It's something we probably need to look at from statute, as we mentioned last time. I don't want to rehash it because it's not necessarily key to today's conversation. And then, do we want to get into the recommendations in the report now, or? Okay, great. Are there questions about Intercept 3? Yeah, Pete. I do not have that breakout yet. It's something we can look at. I know historically, people on the highly acute side, we did a matrix because the data system as it right now doesn't really lend to us to do those type of analysis pretty quickly. We are in the process of building a data warehouse. You'll see in the report that will allow us to do an analysis more quickly. What I can say is when we did this breakout by looking who was admitted to the hospital, I'm trying to remember, it was, let me see if I have the matrix. Let me get you that data. I know we did a matrix and I think 14% were misdemeanors that didn't meet inpatient level care that were inpatient. But overall for all types of, whether it's misdemeanor or not, any criminal charge, 53% of those in the hospital met the acuity level of needing a hospital. So 47% didn't among all charges. And of the 47%, 14% were misdemeanors, technicals, or petty offense or traffic offenses.
Why are they there if they don't meet it? Good question.
Because they're court ordered. I mean, that's the only reason why they're in the hospital, because the judge had court ordered it. And that's the whole point of trying to build up a community-based system in which we're trying to get judges more comfortable in referring to the community for services. And we'll talk a little about that, because I think that's something that this group needs to address, is that restoration and clinical treatment are not always they're not necessarily one package. And I think that's a big challenge for judges, where they're court ordering restoration education services, but doesn't necessarily come with very specific mandated clinical services. The pilot I mentioned last time, it was what we're trying to do in Denver, where basically when a judge orders to this program, they know exactly what they're getting. They're getting so many psychiatric hours, so many therapy hours, and so many case management hours when they order this individual for outpatient treatment through this program. But they're also getting pretrial supervision as part of the program, who we're funding. We're giving them money to hire a pretrial supervisor who's mental health trained. So the judge is sort of getting a package that they feel more comfortable. And we met with the chief judge last week. All the groups met, and Carly was there as well from MHCD is going to provide the clinical services. And they seem pretty eager about the idea of, okay, I know what I'm getting, right? There's no question about what kind of services people are getting. So we're hoping that will increase their referrals to outpatient services. Other questions? Yeah. No, this is the only model. So it's sort of where we're starting, and we're hoping it's successful and expanded. I do think that's a key area for this group and to address is sort of, does it need to be mandated, right? Does that concept? Now, not every judicial district has pretrial, so that's a whole different question. That's a bill that was not, a legislative concept that was not successful previously, but should every judicial district have pretrial, and what does that look like?
We have a question from Laura. Are the forensic support team members a part of the communities they serve, or are they centrally located?
I'm sorry?
Are the forensic team members a part of the communities they serve, or are they centrally located?
So they will be they'll be assigned to the judicial district. So we're hoping that there'll be more community. We did the best we could to hire people in the judicial districts where they live, but we couldn't do that for all of them. So some will be traveling quite a bit to those communities. Dr. Rai.
When competency is raised with the forensic support team going, see that individual in the jail, for example?
Yeah, they'll go into the jail as long as the jail gives permission. But yeah, they'll go into the jail and visit the folks. They'll have to use their judgment based on how large their caseload is. Well, we try to make sure we cover bases. Ideally, we want them to go into jail. Obviously, people who are struggling more than others, we want them to be more frequent. Those that are doing well, there may be times where they pick up the phone and check in with the clinician. So we want them to build relationships with whoever the jail clinicians are. as well, like yourself. So for Denver, to have that relationship, so they can just sort of discuss and say how things are going, particularly if the clinician is seeing them more regularly than we are. Yeah.
So tier 1 would be like Pueblo in the hospital. Would tier 2 be like Rise? I was just trying to find.
Oh, yeah, sorry. So the question was, what is tier 2 basically?
Yeah.
Yeah. Tier 2 is inpatient as well.
Okay.
It's just that we have 28 days to admit. Now we're not meeting those 28 days, but that's how it's supposed to work. It means we have a little bit more time to admit that person to hospital. Doesn't necessarily mean that they're needing hospital level of care. They could sort of do the community as well. So there's a little bit of mixed bag in that tier 2, because the recommendation for inpatient, outpatient, sort of a separate question. So if they're court ordered, but let's say the evaluator opines they don't need inpatient, but the judge still orders inpatient, then they'll be tier 2.
Okay, gotcha. Still Pueblo, longer time to admit.
To admit, yep.
But the definitions are in the consent decree.
Okay.
On page 13, it starts at the bottom, tier 1 and tier 2.
So on the phone, the definitions are on page 13 of the consent decree. It starts in the bottom and it goes on to page 14. Yeah, Dr. Rai.
One point. The second recommendation, we already doing that in Denver. What we were having so many competency evaluation requests that I requested the probate court to send me every single competency.
So can you pause on that and I'll read it, and then maybe we can get into the competency.
Yeah, are there any other questions just to clarify anything that Robert has described thus far that's just what's in this intercept? And then we can kind of run through the recommendations and start pulling them apart and adding to them and the work of the subcommittee. Any other general?
I did actually.
Okay, go ahead, Allison.
So how long does it take for, when somebody's arrested, when generally do they raise competency? When does somebody raise competency on their behalf? Lawyers? Anybody know?
So the answer, there's not a specific answer. So a couple of things. One, and I'll obviously let the public defender's office answer this part, but usually a lot of it comes from their representation, right, the attorney. Usually, since they're going to have the most interaction with them, they're going to be the best to be able to say whether there seems to be issues of competency. For the DA's office, it becomes a little more difficult because of our personal interaction. Obviously, there's some sort of different type of outburst in court, but even then, that could just be anger or emotions. Usually, it's going to come from the defense attorney, and or if they're on pretrial release, or they're being screened by pretrial release for release from, if they're first in custody and then pretrial release is willing to take them so we can release them. There may be information pertaining to competency through them, but generally speaking, I'm going to say it's going to come from the defense attorney. Obviously, in the juvenile sector, it also might come from the guardian ad litem. I'm currently placed in juvenile addressing these issues, so it might come from those two parties, but usually the last person to really know is going to probably be the judge and the DA's office. And then we're going to be reliant on, as I said, the defense attorney or any other members of groups such as like the pretrial release, guardian ad litem, or something like that are assisting with their release.
I guess thank you. That is definitely helpful. I'm trying to figure out the timeframes go from when competency is raised. What happens before that? I mean, are we talking about people are in jail for 2 weeks, a month, 1 day?
It's most likely to be months, because realize when we first get a case, depending if it's misdemeanor or felony, especially in the felony realm, we're going to set it for first, second advisement. That's usually a couple of weeks. By the time we set it for preliminary hearing, where a defense attorney is going to have the most opportunity to actually meet with their client, go over the case, and then that's probably where they're going to start getting cues as to what's going on in their mind or their ability to consult with their attorney. You're probably looking at least about a month, 2 months out already. Then at that time, the defense has a difficult decision as to whether they're going to raise competency at that time. Then you also have to take into consideration that there may be issues depending on the nature of the offense. Say if it's a sex assault versus a property crime, there may be other issues that are coming about. So I can't give you a specific, but it's going to be usually probably a couple months, so long as it's not so blaring or glaring the issue of competency that it's raised more or less immediately. I mean, I've been in this office now for 12 years, and the amount of times I've seen it raised, say at first or second advisement, are probably like in the single digits, simply because it would have to be so glaring that everyone in the room is like, there's an issue here that needs to be addressed immediately, but usually it's going to be probably months.
Okay, that's really helpful. That helps me understand that we definitely need to focus on that time frame, that competency timeframe? And then I had one other question, I guess, for you, Robert. In the pilot, is there any individualization of treatment? It sounds like you're sort of selling a package to the court saying, this is what it'll be if they do go to outpatient. Is it everybody gets the same amount of psychiatric hours, same amount of case management?
No, I think there's open for flexibility. I think we're starting at the point of assurance and working from there. And Carly walked out, but because Carly's group is going to be the group providing clinical services. So there'll be some flexibility, but I do think we need to provide some guarantee of medication evaluation and psychiatric, because that's sort of been a challenge. And then the case management, of course, is going to be pretty intensive. I think the one that's going to be really flexible is how much therapy.
Okay.
So, all right. Other questions before we jump into sort of considerations for this group that we're sort of in the process of creating the report that came up and would like the group to, whether they want to consider it or not. Great. Should I just read them off?
Go.
Great. All right. The first one is the recommendation for the subcommittee to consider is collect data around referrals from judicial officers, public defenders, district attorneys, in order to identify where targeted training might be beneficial. Anybody opposed to this concept of collecting more data? I think that would be the case. I think the opposition is going to come on who's collecting data and how much data, who has to submit what.
And just a process question, is today's discussion our last chance to talk about this set of recommendations and to sort of decide on them?
No, I think today's is sort of getting so solely targeted, and then one, if you guys want more information or you want to bring back information for further conversation, we'll definitely have to have some follow-up, but I think we need to decide what direction we want to go in as far as do we just want to go this direction at all?
Yeah, and I would add to that, excuse me, that because, as Robert mentioned this morning, when you think about the number of meetings between now and the time that the report needs to be written, it probably will be the meeting that's focused on this intercept. And then between meetings, we can certainly be collecting more, processing more, but we'll be moving on to the next, and if we can, in the next meeting so that we can get through them all. So this is an add-on.
And what will be the process to make sort of final decisions on all of these different set of recommendations? Are we doing that in separate meetings, one big meeting at the end?
I think it probably depends on what happens in these conversations as we go. If there's real consensus around something, I think we can call it good. But I'm sure there's going to be things that, and also overlap between intercepts that we'll be revisiting. So I think it's going to be a combination of just a process as we go, completing as much as we can as soon as we can. So I know that's not a real definitive answer, but I think it's probably hard to foresee what's going to need to be revisited and for how much.
And this first one's not as easy as it sounds either, because it's collecting from different parties in the court process, where there may not be access to different databases as well. So why it's ideal.
Robert, we had one more question.
I'm sorry?
We had one more question before you dig in. For those making referrals for evaluations, do they have any guidelines?
Well, there's statute, but for the evaluators or the referral coming from the courts, well, there's statute on, it has.
Or even the PDs or whatever, I think.
Well, the judge ultimately makes the decision, right? So the recommendation for referral, no, anybody can raise competency in a court process, but it's ultimately the judge that decides whether that's true or not. I mean, the lawyers can just tell me if I'm wrong, but I don't know. It seems like it's used a lot. So I don't know how often it's actually denied.
This is Allison. I would add that attorneys are under an obligation to act ethically, so they certainly can't raise competency just to delay or do some other thing. And there are statutory standards of what is considered competency, so it's going to be up to the person making the referral, which, as we've heard, is generally the defense attorney, to look at the statutory requirements and then act ethically in saying, do I think my client actually may be incompetent? So that's sort of the standards.
Thank you.
Summer, in terms of process too, do you want today to be moving into defining accountability and who's going to be doing this as you described for the blueprint in this discussion, or do you want us to think about that coming through more in the survey as well? I don't think we're necessarily in a process we're ready to dive into that.
I think we can all be thinking about that. But I think we'll have to readdress this as we go a little bit further into the conversation.
So maybe just a helpful frame to be thinking about it as we go will be help us come back to it more efficiently. Richard, were you going to say something? Oh, okay.
So I think the question that was asked by Zoom is helpful because this first one's really about sort of an assumption that if we better train people making referrals, we'll reduce the number of referrals. I mean, I think that's where that's going. Yeah, I agree.
As should be more, maybe better, I'm not gonna say that. I'm not gonna say that all referrals are not appropriate, but I think you'll have better targeted referrals if you have better training to know what you're looking for.
And right now, there's sort of blanket training going on for as much as we can with the judicial we're working with state court administrators for judicial officers, PDs, any conferences when we can, OMPOC meetings when we can. So there is training going on. The question is, do we really need to collect data around referrals in order to target training, or should we just be providing training to all parties consistently, ongoing? I also would like to see online training so we don't have to keep going in person to train. We'll start with Peggy and Carly.
Collect that data, and then you can look at what community resources link with the referrals. It might give you, and that's step 2, I guess, of what this group might do, but it might give you ideas of what could decrease those referrals.
So I agree. I actually think that's might be a better target. Do we really need to know who in a judicial district, or we just need to know which judicial districts at what rate they're referring, and whether we're providing them with the information for their judicial district? And we're creating binders for all judicial districts of all the services available in the judicial district for the judicial officers. And the Bridges program is working with us and sort of so we can get that information out, because they're really the Bridges program is going to be the one that's going to know their community services the best. Carly?
And just as a side note, I mean, you know, certainly more training across the board is never a bad thing, but I worry a little bit when we kind of try to maybe manage or dictate, you know, referrals coming in when it is the attorney's obligation. I mean, I kind of liken it to my obligation to write a mental health hold. At the end of the day, if I'm concerned, you know, that someone meets that criteria, I'm going to make the referral. And that is my obligation. Kind of, you know, we would hope that everyone's very well trained, but I wonder if that's really the most effective way to reduce referrals.
So I'm seeing a lot of shaking heads, yes. So maybe this is not something we want to move forward with. As far as we're obligated to do the training anyway, just to do the training to the different judicial officers and lawyers and make that training as easily accessible using technology as possible. Anybody opposed to sort of that answer? Dr. Martinez?
A lot of this, we may already have this data. I'm thinking, as an evaluator, clearly over 90% of the referrals come in because public defenders request these competencies. Very few come in from DAs, and usually they come in from DAs because DAs legitimately are concerned about appellate issues. They don't want to move someone forward that they're concerned there could be an appeal up the road. And I think the same thing with judges for the most part. So, and maybe my attorney colleagues here can verify this, but it seems like it's over 90% come from public defenders. So if you're going to target, what I'd be interested in is what motivates public defenders to raise the question, because you see an array of reasons, anything from I just can't talk to this person when I met with them, you know, for 20 minutes, to the fact that, I mean, you know, there may be other reasons, like I'm just so concerned about the behavior of this person in the jail. It's a way of getting some treatment or getting some intervention early on, independent of the competency issue. That can come up sometimes. But anyway, maybe the attorneys could comment a little bit about what they see as some of the reasons. I mean, usually it's due process constitutional reasons, don't get me wrong, and ethical reasons. But
before we go down that rabbit hole a little bit,
go ahead.
I want us to make sure that in answering that question, does that alleviate any of the goals that this group is supposed to answer. Because I want to make sure that we don't go down just for knowing information. If we're going to want information and know information, that it really is going to lead to sort of a better system, or is it a curiosity question? Well, do you think it will lead to a better system?
Well, the only reason I'm raising is because I know there's been a lot of rumors over the years that, there's a lot of, and I think it's unfounded, but criticism of public defenders saying, oh, damn, they raise this question all the time, when sometimes maybe it's not necessary. But my own sense is they raise the question legitimately, because there really is either a mental health history or there are behaviors that are interfering with one or the other prongs of the Dusky standard. But I'd let my colleagues, and you're right, Robert, we may not need that data. Maybe we already have an answer.
I would love to just say one thing real quick, because I was a public defender. Number one, we can't really get into that because there's no way that you could on record have a public defender admit that they raised competency issues when it wasn't specifically for competency. So your answer would always be yes, every single time that's what it was for, and we have to assume that that's true. But I guess I also want to point out the way I'm reading this report, Robert, on page 43, it looks like overall competency, when people raise it, they're found incompetent 30 to 40% of the time. And when it happens in Colorado, they're found incompetent 57% of the time. That seems like a positive thing, that more people that we refer actually are incompetent. Am I reading that wrong? And if that's correct, then it seems like maybe if we're doing better than the standard, we shouldn't even be as concerned about our referrals, and we should be more concerned about what happens around that.
So, I'll answer that question. I just want them to weigh in on the answer to Dr. Martinez's question.
I think that just for sort of those in the room who aren't as familiar with raising competency as Dr. Martinez is as I am, is that what people should know is that the lawyer has to have, once the lawyer reaches the threshold of having a good faith doubt that a person is competent to proceed, they have to raise competency in advance of any critical stage. So it doesn't mean they have to do it at that exact moment, but before your client decides to waive a right or to plead guilty or to proceed to trial, the lawyer has to raise competency. Otherwise, the law says the defendant is essentially not present. It's like prosecuting a person who's not there, even though they may physically be there. So the standard is fairly low and really puts the onus on the defense lawyer to identify that challenge. And I was going to point out the statistics that Allison mentioned, and would say additionally, if you talk to public defenders on the ground, they really feel like their client, some clients who are then found competent by the evaluator were in fact incompetent. And so in some sense, the 57% from a public defender's perspective, actually our rate of predicting whether someone is incompetent based on our interactions with the defendant should even be reflected as higher, because we disagree ultimately with the evaluator's opinion. But then that's worked out through the process of challenging the evaluation if that's what we think, or sometimes these things are very on the cusp. They're very difficult for both sides. I think the evaluators sometimes struggle, the lawyers sometimes struggle about which side of that line the person sits. So that's what I would add to the conversation.
And that's why there is a second evaluation process, right? Now, to your question, there's two sides to that coin, right? One of the things we are doing is we're looking at inter-rater liability. So inter-rater, not like a true inter-rater, but we're looking at sort of different evaluators' percentages to see who's low, who's high, and if there's consistency. Now, if everybody's operating in that bubble around 60%, then we have good confidence that they're accurate, the evaluations are accurate. If they're all over the place, then we have some concerns about the consistency between evaluators and their numbers. So that's what we're looking at right now internally. We're sort of looking at the different evaluators, like how often a percentage incompetent, competent, because we want to see some consistency in the range, because no reason to believe that one evaluator, with the exception of the person that does the inpatient evaluations, that in between evaluators, that there'd be a wide range of reason why the rate of incompetent versus competent. That's true for both sides. We don't want somebody to be really high on the competency side in relation to their peers either. We want to make sure that everybody's doing sort of a solid evaluation. So we are working with the special masters, you're familiar with this, for the group, to make the training consistent and sort of make sure that we check in with the evaluators that regularly, that they're getting the feedback on how they're doing and that there's consistency. So we're looking for the outliers. And I think that will make the data more consistent to get to the point that we feel comfortable that that all the evaluations are done to quality and are accurate.
So I guess, and just to think about how these are connected and move us on to another recommendation. I mean, recommendation 3 around implementing mandatory training programs for evaluators feels like kind of the other side of this. I mean, there's what you're saying, do we really need to collect data to identify who needs more training? Maybe everybody just needs more training. Is that kind of what number 3 is saying? I mean, or do both of those need to stay, I guess is what I would ask.
So thank you. So number 3 is what we're talking about. So for number 1, it doesn't sound like the group wants to move forward with collecting referrals for the purpose of targeting a specific person in the court process. Anybody disagree with that? All right, so we'll take that notion off. I will say one thing that I would like to ask the group, and I think this would be an easy answer, is collecting data about which judicial officers recommend a percentage of recommending outpatient versus inpatient based on their charges. I'm seeing a lot of shaking heads. Anybody opposed to sort of targeting judicial officers who are higher? And this is not placing blame on them either, because there could be things that the department could do, like we're doing with the Denver pilot, to make judges more comfortable. But that only happened because we went to the chief judge and said, hey, what do you need? And then pulled in MHCD and pulled in pre-trial. So anybody opposed to sort of looking at those judicial officers that have a low percentage of community-based referrals?
Gathering data to find out
Gathering
which
data,
ones.
so the department should sort of approach judicial officers to have a low percentage of community referrals to find out why they're not, and then helping them sort of, whether it's education or whether they want to see a more targeted program in their community. I'm seeing a lot of shaking heads, yes. So we'll move forward as that as a recommendation for the
And that seems to be where motivation data would be more meaningful, because we could actually do something to impact that decision as opposed to with the.
So I'm hearing that the department should gather data about which judicial officers do not utilize community referrals as frequent as their peers to engage in a conversation about what resources are needed for them to do so. Kyle.
I was just going to add that I think it's important to think about that, given that certain judicial districts, certain folks might be dealing with populations that have crimes that are at a higher level on average than others. We think about when we define peer, we want to think about sort of where they sit in the judicial system and the types of defendants that they tend to be dealing with.
So I agree. So for low-level crimes, right? Maybe that's where we start, because felony 1s, 2s are pretty much they're going to be in a lock setting one way or the other. So I think for low-level crimes, we target those judicial officers for conversation. Great.
I'm going to just use my inside voice. I think we also have to look at the communities that you have to underlie the communities to that, because we know there are communities in Colorado that have no outpatient services in those areas yet. So judges can't order them if they don't exist. So I think you have to overlay multiple levels of data to be able to look at that fairly as well.
So I agree. And one of the department goals this year is to have 100% coverage, but the counties that don't have it are really small referrals. Grand, Jackson, Hinsdale, Dolores. I mean, we're talking about populations, really small populations. We are not talking about any populous counties that don't have, well, one, they all have mental health centers for services. And two, for the restoration education part, 84% of counties have services. The other 16% that don't are those counties that are pretty remote.
Yeah.
So I guess I would just want to add to that I think that would be the conversation. So I think it's fine if they are referring at a low level and you go to them and they say, there's nobody providing what we need. That's exactly what we want to know so that we can get providing what they need.
Great. And I was going to say the same exact thing. So I think we're good with recommendation 1 to move forward from. I want to skip to 3, implement the mandatory training program for evaluators in an effort to increase the quality and consistency of evaluations.
Senate Bill 223 doesn't quite say this, but it does imply, and Dr. Martinez is work with us as a department to sort of, it does say that we have to work with a university, basically, a higher education in Colorado to make sure we're developing a program that's consistent and it meets those standards. Anybody think that the department should not work on and spend energy on mandatory training for evaluators to make sure we have ongoing quality assurances?
I think it's very important to make sure they're qualified.
Yeah.
Raina, can you please repeat that?
I think it's very important to make sure that when you're talking about people's rights or even just any kind of thing, that people have the adequate training.
Yeah, we agree. Somebody had their hand up.
So one of the things I was going to say is, are we sure that it's a training issue and not a liability issue or something like that, in which evaluators are not opining somebody as competent or incompetent based on a liability question versus, I can imagine as an evaluator, I might not say somebody is competent if they have no supports, they have no housing, they have everything that creates a mess that they would not be safe without any protective factors.
So that's part of the training, right? The part of the training is the statute's clear and the process is clear what evaluators are supposed to be evaluating to. And your statement is somewhat of the reason why some of the evaluators were resistant to opining about outpatient, inpatient, because they didn't want to go outside sort of that scope. But I think that's part of the training, is make sure that they're doing exactly what's being asked of them and not outside that scope. So one, because there is a legal process that's involved in this, and that they're consistent with sort of what that is. And I think training will raise those questions, right, of those evaluators that maybe are looking at other things, such as protective factors, about when really they're just supposed to be opining whether they're competent to stand trial.
Do the evaluators have any liability protections?
So statute 223 did put protections in for evaluators. So it did reduce that liability concern. Not that, honestly, that we really thought there was a liability there, but it did make them feel a little more comfortable in sort of hearing their concerns and their worries. And that's why when I said earlier that I really want to reword the question of whether this person should be outpatient versus do they clinically present as if they need to inpatient restoration in order to be restored. I think changing that question and making it really precise will help the evaluator it's the court's responsibility to decide whether there are protective factors. If an evaluator says they don't need inpatient, then that's when at court, they're like, well, do you have housing? Are you safe? Or are you going to be victimized? The court needs to decide that, not the evaluator.
For reference, I just want to show people that they can look at Senate Bill 223, which is in one of your tabs on page 25, just under section 11. It talks about the forensic evaluator training that was mandated by that bill. And so the department's essentially going to have to do this. I guess maybe this recommendation is, do we have any further thoughts or, ideas about it?
Good. So we're good to move on from this one. This is oh, sorry.
Oh, I'm sorry.
Carly, can we make sure you use the mic so people on the? Yeah, we will. Okay, so it sounds like we'll leave number 3, one, because statute requires it, but it's also important for to hear that the subcommittee supports it as a process of targeting our energy, and so I'm sure Dr. Martinez will be the silver bullet to fix it all.
No pressure.
All right, so getting back to number 2, which is going to be an interesting conversation. Jail mental health services should prioritize defendants ordered for competency evaluations in an effort to stabilize the individual before competency is raised. Now, before we get into this, I should divulge that we have adjusted OVH's jail-based service contracts because statute under, I forget what, I know it's letter E, but I forget the exact statute, says that we have a OVH can in their contracts require to prioritize this competency population for services. It is in statute, and we have sort of mimicked that in both the consent decree and into the
into the contracts. Now, I say that, but that's not really as much on the evaluation side as on the restoration side. So, because so to be clear for the folks that may not operate in this world, when your court order for an evaluation, it's just that, your court order for a service. When your court order for restoration, your court order into the custody of the department. And that is where the contract right now, when you're court ordering the custody of the department, we sort of mandate that the jail prioritize that population for services with the funds we give them from OBH. It does not mean that necessarily that the people getting evaluations are prioritized by those clinical services. So that's clear. And it's important because for the restoration side, it means those folks have to get served. And if you run out of money, then that means other populations are gonna be potentially lose out on services. Okay, so I know Moses and Carly, you had comments on this, and Dr. Rai, you had the first comment, so you go ahead, Dr. Rai.
So in Denver, what we are doing is the district court sends the orders for competency to the probate court, and the probate court's secretary then emails me. So every day I'll get a bunch of orders. I will print those orders out, and I will personally go and see each of those people. And then I will see, and usually I'll print them out on a Friday, and then I'll go and see them, or I'll ask one of my PAs to go and see them. And then we just go and see them and see whether they are, whether they can be restored, they can get better on meds, or if something else going on, or if they are already seeing one of my nurse practitioners or psychiatrists already in treatment and we don't need to do anything, or whether we need to send them for court-ordered meds process. So we kind of like have eyeballs on them. But definitely, we don't have the service to see them that frequently. So like supposing sometimes competency be raised and somebody's already in treatment, but we'll see them every 6 weeks or something, and then by that they'll still be incompetent by the time the evaluator goes. So I mean, we are trying to do this informally, but definitely it would need one whole FTE of like a advanced practice provider to actually go and see these individuals and prioritize them.
And I should add that Denver has a behavioral health unit. They have Denver Health professionals helping out. Not all jails have that intensity of clinical services available to them.
Or any.
Or any, for that matter. So mental health services are not legislatively required in statute. It's an option for jails to accept funding. Actually, they have to ask for the funding from OBH. And right now, I think it's 17 jails. So not all jails have mental health services or will take it. That is something this group should talk about, whether that's a legislative initiative that should be required when we talk about jails and mental health services. Because like I said, people getting evaluations are not in the custody of the department. They're in custody unless they're ordered inpatient. So there's still a lot of questions about what degree of clinical services people are receiving based on the availability of clinical services in the jail for the evaluation population. Carly and Moses?
I'm just confused a little bit, even before getting into the content of this, so I might just need an explanation. So the recommendation is to prioritize defendants who've already been ordered for evaluation so that we can stabilize before it's raised, but wouldn't the evaluation only come after it's raised? So I'm just not sure who we're targeting and to what end.
Sure. So it's really targeting those that if they could get on the right meds between the court order evaluator meets with them, and then when they have a court date where the judge basically opines. After the court evaluation's been ordered, right? But before they go to court to discuss the evaluation and make a decision. Now this is, I should say, when the special masters come next on the 29th, we should revisit this topic because it's something they're passionate about. And they believe that if we could stabilize more folks before you get to court, there may be an opportunity to order more people for outpatient instead of inpatient.
I think just the way it's worded is a little confusing because we're saying prioritize them after they've been ordered so that it never gets ordered.
Okay, gotcha. So we can reword that. Yeah, so we can rework. We'll work on wording that. Or you need the right psychiatric meds to stabilize. Yeah. Yeah.
Have a suggestion on that one. I think to maximize, you know, the success of this recommendation, we should be looking at individuals coming in with multiple findings of ITP in the past, and prioritize those individuals so that comps never raised, hopefully, so that we're not waiting for it to be raised or an evaluation or anything that they've been found ITP 5 times in the past however many years. Let's prioritize them.
I agree. And can we parking lot that to when we get to the court intercept? Stephanie, you were right for the parking lot? Because I agree, there's a couple other scenarios around IGD as well. When we talk about avoiding competency referrals, let's do that in the court intercept session. No, I was going to say the same thing earlier too. There's going to be a lot here that's going to rely to avoiding people from getting referrals. Let's put that in the court order, the court intercept section when we meet on the court process. I think let's today focus on those that we agree should be eval'd. And we'll change the word before competency is raised at the end of that sentence to before the competency court hearing. Competency determination court hearing. Does that work for everybody? The very last part, instead of is raised, is before the competency court hearing.
Yeah, okay. I did have one question on who are we prioritizing them over?
Well, anybody in mental health with jail. I mean, in jail with mental health services.
So potentially you could bring some folks up to stabilization while you're concurrently reducing other folks into lower levels of stabilization.
Which could potentially then make us have more referrals, because now these people have been referred and we get them all good, but then we have neglected the folks who haven't been referred and they get destabilized and now they're referred. So this could lead to increase.
Yeah, I think maybe another tweak on this, Robert, would be to, instead of prioritize, how about to create a system to identify these individuals for intervention? Because I think that, and Sasha may speak to this a little bit. I mean, when we started this, jails often just didn't have the information who was going to be about to get a competency eval and who wasn't. But I think Sasha is describing a really nice system where if you identify these people, then you make it a priority to go evaluate them and get them started on meds, which I think is the goal you're trying to make here. So anyway,
Dr. Martinez, when you say evaluate, you mean competency evaluation, or you mean medical?
No, I mean for the medical team to make, in other words, to have a system in place so they know who has been ordered for a competency eval, kind of the way Dr. Ride described.
Yeah,
he gets a list of people so he can then very quickly go do rounds and make sure those people are getting a psychiatric eval, and if they need meds, they get on the meds.
I agree, but what I'm hearing from the group is should be limited to those that have competency or anybody with mental health.
No, that's why I'm saying get rid of the word prioritize, because the concern here was that others are going to drop off. I'm saying jail mental health services should create a process to identify defendants ordered for competency evals in an effort to stabilize before the competency hearing.
So that goes back to my original statement that we would need legislation to mandate mental health services in jail for individuals.
Also, I think you can prioritize provided you through your jail-based behavioral health service budget provide an FTE to that jail. So supposing, like you already mentioned, if OBH has JBBS budget and it says, hey, we're going to give you this money, but one FTE should be just doing this stuff extra from what the jail is, then I'm sure the jail will be happy to do it, because then they can take care of this kind of work.
That's the thing, is we don't have the resources for extra, right? So that's the question. I think we keep going back to about, that's why the word prioritize is in there, because there's only, that's not a lot. I think there's like $5 million total statewide for jail-based behavioral health services, both substance use and mental health. And it's not legislatively required that they provide services. So our only avenue currently is through our contract that we give to those jails that want to take it.
But maybe this is a legislative recommendation, right?
That's sort of where, yeah.
So I think one of the things to keep in mind before we say we're going to require everyone to have jail-based services is not all jails have capacity to be able to render such services. I know for Pueblo, our jail is super overcried out to the point where it would be counterproductive and countertherapeutic to try and run such high-intensity treatment programs in a jail that's already packed to the gills and doesn't have capacity for the individuals they already have in there. So you are saying select between competency individuals and other individuals who need mental health services who are in desperate need before they enter the competency.
So what would you recommend those jails do?
I mean, it's one of those things where to change what we're talking about is going to create a substantial need for infrastructure and funding, because the jails need more money to get bigger so they can hire more people and to create all these places, and that's not going to be something that happens.
Yeah. Well, no, that's on the table. Legislative budget requests are on the table from the governor's office. Joy and then Moses.
So we're talking about the need for more treatment in jail. I don't know if we should be talking about treatment in jail. I think that tends to be perpetuating a system that we're already fighting against anyway. That's not the form or function of a jail. It's become a necessary, unfortunate function of a jail. My question back is, at what point is it when they're deemed not competent in needing restoration, they become under the custody of DHS?
When the court orders the restoration, when they
become court ordered to do restoration. Yep. So at that point, do you all have other physical locations besides the RISE program and the hospital? I think we might need to discuss that option, because again, I don't know if jails are the right alternative to do restoration, which also needs to involve more than just that
real clear, there is no restoration in jails. before the plaintiff's mind blows over here. That was really clear. No, the restoration does not occur in jail. What's occurring is interim services. So if they're tier 2, ideally what it's supposed to be is while they're waiting for admission within the time frames allowed, that they get services when the court orders for restoration. So within 28 days, basically, is that they're getting services in those 28 days. I agree with what you're saying to an extent, except that what do we do with people that are picked up with charges, that have charges, that committed a crime, they're going to get arrested, and if we offer them nothing, then what do we do? This sort of goes hand in hand with who shouldn't be going to jail or getting competency at all, with if you are going to jail, should you be getting something? And we are addressing a population larger than just competency when we say, should people have the right to services when they go to jail while they're waiting? So, Moses?
My original comment was basically said by these two. I mean, if we're going to be talking about increasing or requiring jails, I mean, it's a huge infrastructure. A lot of these jails just don't have a room for therapy. So we're talking about huge infrastructure investment, and is that really where we want to put our resources? But my new comment is that I think we don't necessarily need to reinvent the wheel in all of this, and I'd really just encourage us to look at some work that's already been done. So if we're talking really acute needs, the CCJJ just put out that other recommendation when was that? Peggy, you were a part of that work, to get those different facilities where you can transfer really acute folks out. And as part of that research, Peggy, I'm going to call you out again, we found all of that research of what California is doing with the regional centers and things like that. So how do we, if our goal is to get people into treatment, how do we put the resources where we want them to get treated? And if everybody's having this strong of a reaction to treating them in jail, where else do we get these people to go? Knowing that they have charges, knowing that they need to be in correction.
If I could just, I hear you. I mean, the last place that I want anyone with a mental health issue to be is in custody or behind bars. That is a larger system issue that's been going on for decades, that we have tried to arrest our way out of substance use disorders and mental health problems. And that requires a larger system overhaul that we're not, I just, certainly agree that certainly should not be the case. But, I think our focus for this group is that we have an inordinate number of people with mental health issues in jail, languishing and suffering because of long competency wait times. And how do we shore that up so that we can get them out in the least restrictive environment, and then also maybe affect some change to work on the larger system so that people aren't, being arrested and being held in a jail with mental health disorders. So
I just want to do a little process check. I'm sorry to interrupt the discussion. We're wrapping at 11:30. And so we have 15 minutes left. So this was a trial of this process, and we're seeing that it's taking some time. So what I would suggest to Robert and Allison is that we allow them to get through the rest of the recommendations, and we will try to gather some more of this input virtually from you between meetings, and then make sure that we're holding out the full 2 hours, because we're also going to lose next time with our, not lose it, but we won't have as much time for this conversation because the special masters will be joining us. So if we can get through them and then we can get some feedback from you between meetings, I think that's probably the best way to move forward.
Okay. For the second one, I want to sort of summarize what I think I'm hearing. One, secure treatment options other than jail is the preferred method, and I agree. Florida and Arizona have used those methods to address some of their competency issues as well. So I'm hearing secure treatment. Anybody opposed to secure treatment as an alternative to jail?
Not opposed to it. I just want to make sure. I mean, I don't want to go in with a fiscal note recommendation of $100 million to build these places. So I think we can maybe prioritize one, having that, and then two, what would we do if we don't want to go in with 100?
So what is, if homework we do, knowing that mental health and people are in jail with mental health, not just for competency, but there are people in jail with mental health, people for homework create a prioritized list of the preferred options, and maybe list your 3 in order preferred options for people with mental health that are in jail, they're needing services. And you can sort of write those 3 down, because there's going to be different costs for different solutions. And you know, for a secure treatment for in Colorado for, let's say, 100 beds, it's probably going to cost about $40 million to operate, and probably around the equal amount to build out, or I'm trying to think about state properties that we own where that, if we did that, because it's something, by the way, I can just say that actually, because we introduced it last year for Ridgeview for competency. Now, if we didn't limit to competency and we opened it up to as an alternative for jail, for people who law enforcement picks up someone with mental health, instead of taking them to their jail, they drop them off in secure treatment. That was one of the things potentially, but what we would not want, and what I would want us to tell the larger behavioral health task force is, whatever you build in the criminal justice system, you must build the equal amount outside the criminal justice system, so you're not pipelining into the criminal justice system. I say that all the time when we talk about DYS kids and juvenile justice. Is sometimes we've heard judges over and over commit kids because they're like, well, DYS has the services. Right? So we need to make sure whatever we build in the criminal justice system, we equally build outside the criminal justice system. Does everybody agree with that? Anybody disagree? Great. So we got a little homework, preferred list of ideas on how to, people that are in jail with mental health services, how should they be served, and ideas on how we could serve them. It could be inside or outside the jail. Peggy.
Provide healthcare. And I think there's a statute. I was trying to scroll through here, and on my phone I can't find it, but I'll get that parity. Right. So if you have to, mental health has to have parity with physical health, and so putting those two together, I think we could say.
Except that jails are not identified as a health provider.
No. Yeah.
That's where we run into.
But if they're required to provide, because they have custodial care, they have to provide. They have to take care of people.
So I'll let the lawyers figure it out, because it does not seem like that's applied. What's that?
I'll find it for you.
Email to the group, so I'll let the lawyers decide. All I know is today in Colorado, that's not how it functions. So. Yeah. Can you use the mic? Sorry. For people on the phone, thank you.
It's helpful to CDHS knows how much it would cost to build a 100-bed facility. I would also be curious to get a super rough ballpark of how much it would cost to require all jails to allow for comprehensive mental health services. I think that would be a huge number.
I guess maybe what it can do is, if anybody has connections in Boulder, because they just passed the tax and are in the process of building it. Actually, I can talk. We have a RISE program there. They're building a mental health treatment facility as well. I'll try to figure out what that is. And I know Arapahoe wants to, so I don't know if they budget out. So I'll connect with one of those two folks. Summer, can you write that down for homework and try to see if I can get a price tag? Yep, sure, great.
I mean, I think our bottom line that we want is people are getting mental health services from the get-go when they're arrested. Certainly, people with severe mental illness who are presenting as competency issues, we would like not to be in the jail, but right now they are, and they may be in the future despite our efforts, and so we want to make sure that we are covering everybody is sort of where I'm coming from.
Agreed. All right, I'm going to move on. Continue to provide more information and education to the court regarding competency evaluations and community-based options in an effort to increase the number of individuals referred to community-based services. I feel like we've already discussed this one in length. I don't think there's any, I think people supported of sort of removing that first recommendation in lieu of this. Moving on, develop a filing access system for forensic support team and Bridges liaison program that will allow stakeholders to easily access information about an individual. I don't know why this is listed because we are doing this already, honestly. We're creating a court database. I'm sorry, a forensic database where multiple different parties can access the information. We received the funding July 1st. We're building it out. Anybody have an issue with the database or has an idea about the database that maybe that we're not thinking of? Maybe that's a better way to phrase this.
Who gets access when we say allow stakeholders?
Yeah. So that's a good question. I don't know if that's been flushed out yet. I mean, Bridges, obviously, forensic support, OVH, but then we start getting to the legal world of who has access to information that can be used in a trial. Yeah, and HIPAA release. So we run into sort of the issues that we've been hearing lately about confidentiality and HIPAA. I think that really has to be flushed out.
Because I think we were really looking for defense counsel to be able to have this information so that they aren't like, did they get moved to the hospital? Are they at Rise? Where are they? So they can easily get in contact with them. But obviously, just as you guys are saying, we don't want this very private information to be given out too easily.
So if Bridges had protection, the defense or the DA would know to call the Bridges person and just say, hey, can you just tell me where they're at?
Right.
Right. That way you're not giving all information, you're sort of just giving low. But we need to identify which information would
fall under which, yeah.
Yeah.
You might change the word stakeholders to participants. Because stakeholders sometimes are outward.
Yeah, like I'm a stakeholder, I think, but I shouldn't have that information,
Right.
Yeah.
So maybe we're gonna have to have some more conversation around confidentiality and sharing information at some point in the process before session starts in January. So maybe we will parking lot this topic because I think everybody agrees, but we should parking lot this include around the confidentiality conversation about what information and which information should be shared. Everybody good with that? Great. Sorry, I'm just trying to get everybody out of here in time. All right. Exclude all non-Victims' Rights Act misdemeanors for competency services. I think this should go into the parking lot for the court. Unless anybody disagrees, but I think this is really about who shouldn't get, should there be a population that doesn't get evals? Now, this is a little broader than people who we know have been ITP in the past. This is saying that we don't even go down that road for certain crimes. Now, other states have done this, right? Petty offenses, traffic violations, which becomes sort of this is really tricky.
Well, what happens to them then? I mean, did the charges get dropped or are they forced to go to trial or plea when we know that they may be incompetent?
Yeah, that's a great question. I think, so when I hear exclude, I mean, you're right, it could be either way, right? It could be, are we saying a plea or are we saying just dropping charges, right?
Right, because you can't plea if you are incompetent. Exactly. Obviously, dropping charges would be my preference, but I don't know what the other. Right, because then otherwise everybody could say, yeah. I mean, and of course, we're relying on the people not bringing it up inappropriately, but that would be.
Restoration not being different, right? So we need a for the basis to why we're dismissing. Otherwise, as you stated, everyone would say competency issues and then would ask for dismissal.
Yeah.
Well, wait, we had a recommendation about something that Minnesota does. What was it, Sasha?
So I was thinking that rather than excluding, I was thinking excluding non-VRA misdemeanors from inpatient evaluations and restoration. Like they should just automatically go to out of custody restoration and evaluation. They should never be ordered in custody because they are low risk for danger to others. They're non-violent offenses.
Unless they're 2765.
Yeah, yes.
So tier 2 misdemeanors should be
I don't see like a drug felony for possession, somebody who's psychotic because they were using methamphetamine and selling it and being going to Pueblo or Rice for restoration. I mean, I don't see the point.
So I agree. I'll say, given that right now there is a process in statute for restorations, yes. So maybe the question is, that's another parking lot for when we get to restorations, that those are tier 2 and low-level crimes for restorations should automatically be outpatient. So if we can, Stephanie, you have that?
To which intercept, sorry?
So it's for the next one, the restoration one.
Okay.
For restorations, if you're tier 2 and a lower offense, it's automatically outpatient. Inpatient's not an option. I think that's a big conversation for the next one. I think for evals, it's sort of happening today. We're only getting 12 or so a month. So I think that the courts that process is working today because the bar is higher. All right.
Wait, you think it is working? You think we're not getting misdemeanor folks in jail until their evaluation?
I think right now, since we're only getting 12 out of hundreds of evals a month that go inpatient, I think it's reflective.
But jail. What about jail-based?
Oh, jail-based. Oh, yeah, you're right. I'm sorry. I'm thinking he said inpatient, that's why I'm
Yes.
stuck in inpatient. But jail, no, actually, you're right. So do we want to have, if you are, that's a good question, right? I mean, evaluations, court order evaluations for misdemeanors, petty offenses, and traffic violations should occur in the community, and jail-based evaluations is not an option.
Right.
Yeah, I think that would make more sense. I mean, there's no point somebody waiting 28 days in jail for an evaluation of a non-VRA misdemeanor. I mean, you just lock them up 23 hours a day and a lot of times they get more sick. They may spit at the deputy, get a felony assault charge. They may pick up more charges. So why? And I've seen a lot of horror cases on this one. So I know that they probably, and you already have the Bridges program in court. If they were a licensed social worker, they could even make the determination whether they need an M1 hold or not at that point.
I have a question for the facilitators. Do we have some kind of online ability to have a conversation? I
Yeah,
sound like
we
the
can
president.
figure something out, I think. We'll work on it, how we can conversate.
How we can conversate. You want to add to that?
Just, if we're going to parking lot that, it needs to be not just focused on outpatient evaluation and restoration, but also just diversion and redirection out of the criminal justice system. So a person on low-level offense who's found incompetent to proceed, all the efforts to restore, instead clinical support is a good use of our energies and resources, but restoring them just so we can prosecute them for what's something we're not super concerned about anyway, it doesn't make a lot of sense either. So
and I agree. I think that's a conversation we should have in the restoration intercept about, I think every intercept, we're going to talk about the deflection and diversion and what population should or should not apply. Okay, so I'm hearing that once you get to court for an eval, this is not really a doable anyhow, right? Because you sort of need to be confident in order to weigh in on and then when we get to the court process, we could talk about which population should be deflected or diverted. So I'm hearing that this one should come off in the evaluations intercept.
But what do we think about the?
Oh, I'm sorry, you're right. Yeah, go ahead.
The requiring outpatient evaluations for people who have who have non-VRA misdemeanors.
So I would like to make that an online conversation, maybe a second homework assignment that people can weigh in, because I think there's a lot of legal components to that folks should sit and think about, sort of for those that are low-level crimes that are jail-based evals, should they be outpatient evals and not jail-based evals?
Right.
So that will be sort of an online conversation I think we can have. I think most people are going to be somewhat in agreement, but I know there's a lot of technical stuff that people need to mull over. And yes?
Well, I just want to do a time check. Okay. So we're at 11:30, and I think we have this one last one to go. I want to recognize people's times, and if you have a hard stop, you can excuse yourself, then Robert can go ahead and
this last one, I mentioned it earlier. It's also a little interesting. Should there be a pre-screening for evaluations? So should there be a quick screener before there's a sort of a full-blown evaluation court-ordered? I know some states do that. I'm hearing a lot of head shaking, yes.
The Denver County Court is going to start this process with MHCD.
We'll have people who have a city competency evaluation. If they are found 3 times incompetent in the last 3 years, they'll see a social worker the moment before competency is raised, and they'll have a little screen done, and then they'll tell the lawyers that this person is never going to be competent, and then the charge will be dismissed before they go to court. But they will only be dismissed because the evaluator, the social worker, will take them to MHCD, plug them in treatment, and then let the city attorney's office know that this person is not competent, but we've connected them to care.
Is it court order treatment though, or voluntary?
It'll be as part of their legal process.
I have a problem with this. I don't see how you do a pre-screening and not a full competency assessment and declare someone is likely to be competent without violating their due process under the Dusky decision. So maybe the attorneys will speak more forcefully to this. So I don't really understand. I can see a pre-screening. Well, let me let you guys comment on that.
So before we go to the lawyers, because I know we're out of time, can we pick this up with just for 5 minutes beginning next week? Because there is other states that are doing this, they're looking at this, and maybe Stephanie, we can do some research on what legal basis those other states are doing the screening and bringing it back for 5 minutes only at the beginning of next session. We do need to do public comment.
Yes, that's why I'm standing back here.
Can I just say, when we bring it back, let's consider whether we write it as likely to be opined competent or likely to be opined permanently incompetent. I think that might be easier.
All right, Allison, can you do me a favor, please, and write that language down on a sticky note, because I don't even know I'm catching up with you. Okay, so members of the public who took time to be with us, we want to make sure we give you an opportunity to ask any questions or make any comment before we close today. All right. Yeah, go ahead, Robert.
Closing remarks. This was really helpful. I hope everybody felt sort of like now that we're getting past a level setting and it's a little more creativity and innovation going into where we should go. So I do appreciate the conversation. And if you guys have thoughts in between and you're just not a public speaker, please feel free to email Summer, myself, Allison, or anybody really you want to email the group. You decide who you want to email that's here, but feel free in between groups to do that.
Robert, can I just add real quickly, for the next meeting, it's August 29th. We're at Mile High United Way from 11 to 2. We changed that date because the special masters are going to be in town. They're actually working on their presentation. So if there's specific questions that you want them to address or topic areas that you want them to cover, please go ahead and email me so I can go ahead and get that information to them ASAP.
I think we're good to close, and just expect to get some homework and some questions from us in the next week so that we are prepared to keep moving at this pace as we keep going. So thank you everyone for your patience today.